As you know, in a world where justice often serves the powerful, what happens to those left at the margins? Today, we are peeling back the layers on a system that promises fairness, but rarely delivers it equally. We are talking about the international criminal justice and whether it truly protects the world's most vulnerable communities or not, whether it is minorities, Dalits, or Adivasis. Hello and welcome. My name is Heman and I serve as a Research and Communications Coordinator at the South Asia Research Institute for Minorities. You are tuned into our special webinar on Justice for the Margins, advancing international criminal justice for minority communities. Now you might be asking why international criminal justice and why even minorities? Because across the globe, from South Asia to Latin America, minority communities continue to face violence, discrimination, and impunity. And while the world talks about the law and the order, minorities ask, where is the justice for us? Whether it is, caste-based atrocities, ethnic cleansing, or a religious persecution, they are not isolated events. They are continued patterns. Those patterns that demand attention, our research, and our response. And that's what today is all about. At SARIM, we do not just talk about the minority rights. We investigate, we document, we even challenge the system that fails them. We work with scholars, legal experts, and activists across borders because we believe that justice should not depend on your identity, geography, or even the social status. To help us make sense of this complex and urgent issue, we are joined by an extraordinary panel of thought leaders and practitioners. First up, we are joined by Dr. Anja Mihr. She is a program director at Center on Governance through Human Rights. She has spent years working on transitional justice and has seen firsthand what happens when justice systems are both ignored and weaponized. Dr. Mihr, thank you for joining us. I would like to know that what inspired your journey into this field and where do you see the global justice falling short today? Over to you.
Thank you very much, Heman, and thank you for SARIM for having me again. I would like to give you an introduction to what transitional justice actually can do. And let me see if this works here now. I want to talk about the scope and impact. But first, I will answer your question, Heman, what inspired me? And of course, my own country, my native country, Germany, even though I've worked half of my life outside Germany, but I'm, of course, very much socialized in that community. And I was always wondering how a country that went through so many dictatorships and so many atrocities, including a genocide, actually managed to democratize. So this is the big elephant in the room when it comes up to transitional justice. Can transitional justice and its toolbox, its instruments, which is international human rights law, humanitarian law, and criminal law, as you mentioned, and its mechanisms, such as trials, truth and reconciliation commissions, memorials, can they actually help us to democratize after human rights violations? And one major human rights violation that you find in any conflict in this world is marginalizing minorities. Whether these are ethnic minorities, linguistic minorities, religious minorities, gender minorities, and even in the age. We have a new phenomenon that is part of the transitional justice, whether children get systematically marginalized, whether elderlies get systematically marginalized. And what I'm saying here, and in the context of transitional justice therefore aims to build an inclusive society, because everything that is exclusive, that is marginalized, no matter religion, age, gender, it doesn't matter, it will lead to conflict, and conflict will lead to violence. So transitional justice aims to fix that problem all over the world, no matter whether you are in Europe, in Central Asia, Southeast Asia, Africa, it doesn't matter where. We have always the same thing. And that is really what research tells us today, that these transitional justice instruments and mechanisms, and I will introduce you to a few across the world, and you make up your own mind about it. One more caveat that I like to raise here. Transitional justice, despite its term justice, This term justice is not in a philosophical manner. It is really the rule of law. What transitional justice can do is bring back the rule of law in a society where rule of law was abandoned, and therefore minorities, for example, were discriminated and violated. So the general scope of transitional justice is to delegitimize the past regime, no matter where on the planet, a regime that systematically, for instance, discriminates minorities based on language, gender, age, ethnicity, and then legitimizes a new, ideally a democratic regime, and by overcoming that marginalization, the discrimination, and the violence. So I have brought you examples from around the world just to give you the very large scope of instruments and mainly mechanisms. So when we talk about transitional justice, it's always about instruments, which is law. It's criminal law, the Rome Statute now, including universal jurisdiction. I'm sure colleagues will allude on this, humanitarian law, which is basically applied during wars and armed conflicts. And then, of course, the human rights law, and which comes from the 10 core treaties that we have, which apply, by the way, all around the world, because the core treaties of the United Nations, the human rights treaties, are today customary international law. So it doesn't matter whether a country has ratified these treaties or not. These norms and standards of human rights, which are basically non-discrimination standards and rights, do apply in every corner of this planet. So this is the instruments. The mechanisms could be truth commissions, trials, etc. And I start with this example of Croatia. Croatia was part in Yugoslavia and was part of the Yugoslavia war. It was actually a victim of aggression, of the Serbian aggression during that war. But they also, in Croatia, which today, by the way, is a member of the European Union, they had, of course, generals and an army to fight the aggressor army, the Serbian army. But at the same time, this army also committed human rights violation. And when Croatia wanted to become a member of the European Union, one of the conditions was to extradite someone who was called a war hero in Croatia, but actually also was a war criminal. And here you can see really the transitional justice impact, that it doesn't matter whether for many, you may be a war hero and you saved lives, but you also committed human rights violation under the Geneva Convention in this case, and therefore this aspect has to be dealt with. We don't know the results of the trials, but it has to be tackled with. This is really bringing back an inclusive society. Another example is commissions of inquiry, which you find really across the world, and I know in Pakistan you had them too on several occasions. And one of the most prominent examples is the Truth and Reconciliation Commission in South Africa after the apartheid. And even this photo picture said, when you start a mechanism as part of TJ, then it should be inclusive. It should not only be the victim party that accuses the other side, but also have representative of the perpetrator side, the victimizers, which is in this way the white minority. Commissions of inquiry. This is another image in South Africa where there was a report by the commission, by Desmond Tutu here on the right side, given to Nelson Mandela, who was the president at that time, on the Truth and Reconciliation. Another TJ mechanism actually is, and it might be surprising, is amnesty laws or rehabilitation and reintegration laws. The question is here, and this was the big question in Latin American transition process in the 1980s and onwards, to what extent do we actually charge former perpetrators? Or do we give them an amnesty, a partial amnesty, a blanket amnesty? And Latin America is struggling with this question until today, but they have made some tremendous improvements, which is interesting too. Another big aspect, and which everybody on this planet has encounterments, is memorials. Memorials for the fallen, memorials for victims, memorials for those, in this case, of genocide. This is a memorial in Berlin to memorize the murdered European Jews by the Nazi regime. But you can see it's very modern in this case, and people have to use their imagination sometimes with these memorials. Memorials can be also very politicized. This is a memorial in Bangladesh, the National Martyr Memorial, which is a top-down memorial on the civil war and the war that took place in Bangladesh in the early 1970s. And you always look on who establishes these memorials. Is it a citizen-driven, a victim-driven memorial, or is it a top-down governmental memorial? This, for instance, is another memorial in the heart of Berlin, commemorating also the World War II. And this is a Soviet memorial. And many tourists still ask, why do you have a Soviet soldier in a Soviet tank in the middle of Berlin? I thought you are Germany and you're not Russia. It is actually a memorial to commemorate soldiers at that time. This is Yad Vashem in Jerusalem, commemorating the genocide, the Holocaust, in a very different way. The same is in the Rwandan genocide, where you portrait images and here even the skulls of those victimized and killed during the genocide. This is a completely different mechanism of transitional justice, which we call apology, public acknowledgement. This is the former German chancellor apologizing for the war crimes and the genocide, but mainly for the war crimes here in Warsaw. Because when a state leader apologizes and recognizes wrongdoings, this is the beginning of a TJ process, transitional justice. You cannot do anything beforehand unless the successor government is acknowledging, to some extent at least, the wrongdoings. The same was here for the Rwandan genocide in 1994, where state leaders acknowledged it as a genocide, and then the trials could actually start. Trials is probably the most common, and you highlighted it on transitional justice. We have international tribunals and trials, and maybe my colleagues will go into what the difference between a trial and a tribunal is. I just want to allude that here, this is the example of the International Criminal Tribunal of former Yugoslavia. You can see it took quite some time, but what is remarkable about this, which was the ICTY was sort of the foundation of the modern international criminal law that you will be talking about, and that is that in the 1990s and the early 2000s, nobody thought that key perpetrators would be extradited from Serbia, in this case, to the court in The Hague, and yet they did. You see Mladic and Karadzic, war criminals that were extradited. And it becomes interesting when we also talk about the current cases of the ICC arrest warrants, whether it is on Russia or Israel. This is the International Criminal Tribunal coming out of this. Another aspect is the revival of reparations and compensation. It is a transitional justice tool, and often reparations and compensation is not so much about the amount of money that you pay, but the fact that you pay, that you acknowledge the wrongdoings and you compensate. This is the accord between Israel and Germany after World War II because of the Holocaust. There is another tool or mechanisms of transitional justice which is considered the most successful in terms of impact of transitional justice. That is what vetting and lustration is. That is basically to scan the life of someone during a conflict, investigate, and then trying to rehabilitate that person into the civil society, depending on the level of engagement that person had with the previous regime, the level of wrongdoings. This is the illustration procedures in East Germany. When Germany is dealing with the communist past, you see the files, and every citizen has a file. And according to your file, you were allowed to take political office or not. This is another disarmament plays a role in many conflict-torn societies, where you first disarm both parties and then you start the reconciliation and the security sector reform. Individual engagement in terms of forensics, a lot of civil society is also looking into, for instance, mass graves and trying to recover and also to find evidence of past atrocity. And this was here the civil war in Spain. You have also people who call simply for amnesties, but today for conditional amnesties. As I said earlier, it's very important not to give blanket amnesties, because then you establish a culture of impunity. This is the current arrest warrants, for instance, of the International Criminal Court against President Vladimir Putin in Russia because of his war crimes in Ukraine. But you see the women there, Maria Lvova-Belova. She is responsible for the abduction of approximately 20,000 children from Ukraine to Russia. And this is part of ethnic cleansing. Yeah. So it's a war crime, and you see two generals and commanders who also are under arrest warrant. This we have seen similar situations and also trials, and the seek for commissions of inquiry and trials in Sri Lanka. And this is the most recent one, the ICC arrest warrants against Netanyahu, Prime Minister Netanyahu, and Hamas leader Sinwar, who's allegedly already been killed. But the point here is that these people here are not yet tried. And we will see if they're getting ever trialed, whether actually they will be convicted for what they have been accused. And it is important in international criminal law. It also takes time. And we should not prejudge too early, because what we want is really transitional justice. We want to delegitimize the previous regime. We want to say that regime, no matter whether it's in Bangladesh, in Russia, or in Germany, that previous regime was wrong. It violated human rights. And therefore, this should be fixed in a way. And therefore, to legitimize a new democratic regime, because this one is about human rights adherence and inclusion. So thank you very much for listening to this very short and brief introduction on transitional justice.
Thank you, Dr. Mihr. That was, powerful presentation and examples. Talking about the case of Croatoria, really, shows how transitional justice challenges national narratives. And it is also a reminder that true accountability cannot be selective, especially when talking about the minority communities that are often in the first to be ignored or harmed. Thank you very much for bringing that into the focus. Next, we have a person representing a critical local perspective. We are joined by Dr. Shahrukh Shahnawaz. He is an advocate at a High Court of Sindh and visiting faculty at the University of Karachi. Dr. Shahnawaz, you have worked closely with minority communities in Pakistan. How does justice look like when the law is out of reach? And what role can international mechanism play in bridging that gap? Over to you.
Thank you for giving me this opportunity. I am grateful to South Asia Research Institute of Minorities for giving me this opportunity to speak on a very important issue which pertains to protecting the rights, properties, and dignities and vulnerable minority communities, and which impact all of us. I will try to highlight some of the international aspects as well as the domestic aspects of this particular issue, and I will try to focus my talk on more towards the international criminal law. The end of the Second World War saw the birth of the international criminal law, when special international tribunals at Nuremberg and Tokyo were created, and they prosecuted war criminals for committing war crimes against the civilians of other nations and for committing crime against humanity, against their own people. Minorities were persecuted because they spoke a different language or practiced a different religion or held a different belief. In the aftermath of the Second World War, the international community resolved to prevent such atrocities from repeating in the future, and therefore the world saw the birth of the UN Charter as well as the Universal Declaration of Human Rights. With the passage of time, international criminal law developed. We then witnessed the creation of the International Criminal Tribunal for the former Yugoslavia to prosecute the ethnic cleansing of Bosnian Muslims, and also saw the creation of the International Criminal Tribunal for Rwanda in response to the mass slaughter of more than 800,000 ethnic Tutsis and politically moderate Hutu by government-backed gangs of Hutu extremist soldiers and law enforcement agencies in Rwanda. While the creation of these ad hoc tribunals was seen as a successful response to the international criminal law, the truth remains that these ad hoc tribunals were created in response of mass atrocities which were never supposed to repeat after the end of the Second World War. But here we are, waiting for another such a disaster to happen, even though the international legal order has developed considerably and has come a long way since the Second World War. The greatest achievement of the international criminal law has to be the creation of the International Criminal Court, which is a permanent international court, and with this creation, minorities are now protected from non-discrimination, war crimes, especially genocide and crimes against humanity, which includes under Article 7 of the Rome Statute of the International Criminal Court, murder, extermination, enslavement, forced deportation, torture, rape, and so on. Forced deportation or forced population transfer intended to move persons belonging to minorities away from the territory on which they live, as well as forced sterilization, constitute serious breaches of the Rome Statutes of the International Criminal Court. Besides Rome Statutes of International Criminal Court, there are several important international legal instruments as well, which aim to protect the right of the minorities and include 9 core international human rights instruments and their monitoring bodies: the Genocide Convention, the 1951 Refugee Convention, and its 1967 Protocol. Besides the Rome Statutes of International Criminal Court, we have the 9 core international documents, the human rights instruments: the Genocide Convention, the 1951 Refugee Convention, and its 1967 Protocol, the several ILO conventions, the 2003 UNESCO Convention for the Safeguarding of the Intangible Cultural Heritage, and 2005 UNESCO Convention on the Protection and Promotion of Diversity and Cultural Expressions. Vulnerable communities, however, continue to face persecution in the present day and age, and this failure has raised a very important question for the advocates of the international criminal law, that whether the international criminal law and international community have failed to protect vulnerable communities and prevent perpetrators from committing international crimes like genocide, rape, torture, war crimes, crimes against humanity, and so on. The region of South Asia is still struggling to get rid of this colonial past. When the British left South Asia, the emerging states were faced with challenges pertaining to the treatment of refugees, border disputes, river and water distribution disputes, disputes over allocation of resources, and political struggles between the majority and minority communities. In 2019, the nation of Gambia took Myanmar to the International Court of Justice for violating the Convention on the Prevention and Punishment of the Crime of Genocide and for committing the genocide of Rohingya community. When Rohingya community, due to fear of persecution, took refuge in other countries as refugees, they were mistreated. Their dignity was violated and they were forcefully deported. Though in this particular case, the international criminal law has acted, it was unable to prevent the atrocities and failed to protect the vulnerable Rohingya community. It is worth mentioning that Myanmar stripped Rohingya Muslims of their nationality under the 1982 citizenship law, leading to the genocide which was enacted by military government that refused to recognize Rohingya citizenship rights collectively, depriving them from nationality and basic rights enjoyed by the ordinary citizens. After independence, Pakistan and India had to deal with abduction, forced conversion, and forced marriages of girls, leading to the signing of the historic Liaquat Nehru Pact on 8th April 1950 to protect the refugee crossing the borders, which was even before the 1951 Refugee Convention. So this is a very historic agreement and a very historic document in the history of Pakistan, as well as the contribution of India and Pakistan towards the development of the international criminal law in this regard. This agreement dealt with returning the looted property and abducted women, prohibited forced conversions, protecting religious minorities, appointing special courts, and setting up an agency with representation from minority communities. But unfortunately, the abduction, forced conversion, and child marriages are still rampant. The recent rise of the far-right populism has again provided a justification to treat a minority community for its religion, language, or ethnicity as an enemy. Unless minorities are treated as enemies, the politics of populism remains ineffective, unable to achieve the desired goals and results. Politics of populism and majoritarianism especially penetrates democratic and legal institutions, and then these institutions are used to exploit and persecute minorities. Laws are made under unrealistic fear from a weak and vulnerable enemy, and even though these fears are unfounded, they are weaponized against the vulnerable minority communities. With respect to Pakistan, we can consider the example of blasphemy laws, which are used to persecute religious minorities. Recently, it has been unearthed that blasphemy laws are used for blackmailing and extortion money from innocent people by threatening them from baseless accusation of committing blasphemy under Section 295C of the Pakistan Penal Code 1860. The Supreme Court of Pakistan in the Suo Motu Case Number 1, 2014, upheld the constitutional rights of minorities, but without declaring forced conversions and subsequent child marriages as illegal. Instead, it held that Hindu girls had eloped with men of their choice. However, legal and democratic institutions are the only hope available to us, as was seen in 2021 when the former Chief Justice of Pakistan, Guzar Ahmad, had ordered the reconstruction of a Hindu temple in the province of Khyber Pakhtunkhwa after a mob had attacked it. Therefore, without upholding the constitutional principles of equality before law and rule of law, the minorities cannot be protected from discrimination and persecution. International criminal justice has come a long way and has punished the perpetrators for committing international crimes and protected the victims of these crimes. However, minority communities continue to face atrocities and their rights along with their dignity are violated. They, even though are weak and vulnerable, are treated as enemy, and with the rise of populism, treating minority communities as enemy is not a big deal, which portrays a dark future for the regime of the international criminal law, international humanitarian law, and international human rights law. And therefore, it is need of the hour that international community takes a firm stance regarding the implementation of the international criminal law, and not to let the accused get away under the plea of following superior orders, immunity or impunity, and state sovereignty. I am once again thankful to the South Asia Research Institute of Minorities for giving me this opportunity. Thank you.
Thank you, Dr. Shahnawaz, for that important overview. As you rightly pointed out, that the creation of ad hoc tribunals and related ICC marked critical moment in international criminal law, but they also came too late for those who suffered in Rwanda or the elsewhere. Thank you for grounding that in such a clear legal details. We were, I mean, also expecting to be joined by today by Professor Keshesh Chai. He's a renowned legal scholar from Brazil whose work bridges the worlds of geopoliticals and minority rights. However, Professor Chai is currently traveling to South Korea to represent his work at an international conference, and he might not be able to join us live today. But we truly appreciate his commitment to global justice and send our best wishes for his presentation. Since we are at the end of today's discussion, I want to leave with you this that justice is not just about the verdicts; it's about the visibility. You know, too long, the stories of minority communities have been erased from the official records. Today, we begin to rewrite that. We spoke about the power, protection, international laws and policies. But more than that, we spoke about the people. I mean, people who deserve dignity, equality, and safety, no matter their faith, caste, ethnicity, or the backgrounds. To our esteemed speakers, Dr. Maher and Dr. Shahnawaz, thank you very much for leading your voices to this critical dialogue. I believe that together, let's keep working for justice that does not exclude the marginalized but centers them. I'm Heman Das, and this has been Justice for the Margins. Until next time, stay aware, stay active, and stay commentator. Lastly, thank you very much for joining us for today's discussion and taking your time out for this, I mean, critical and timely conversation. Thank you, Dr. Shahnawaz and Dr. Anja Mihr. Okay, thank you.
Thank you very much, Heman.
Thank you
Take
very
care.
much.
Bye-bye.